I have a feeling this one will perhaps stretch in past lunch, but let's see what we can do.
Good morning, Mr. Chair, Commissioners. Ed Santamaria, Director of Public Works. PH4 is a resolution accepting the final plat of Battersea Woods, located along the south side of Battersea Road and along the northwesterly side of Ingram Highway.
Thank you very much. Before I make a motion, I'd like to discuss this for a minute. And I'd like to start by thanking the neighbors for getting as deeply involved in this as you have. It used to be everyone around here was a real estate agent. Now everybody is a planning and zoning expert. And funny enough, it's a shame that you feel that you have to be. I was most recently a resident before now being a politician. And so I can empathize very clearly with what you feel, and I recognize this but during my campaign and before. There's a reputation that we have as a city, a feeling amongst the residents, warranted or not, that things happen here, planning and zoning-wise, development-wise, that aren't quite straight. That somehow a developer will get their way, and that it then comes to us and it's simply voted on. In this very simple, small issue of a replat, the residents have asked me to sort of pick at a small scab and see what's there. And the discussion I'm about to have is actually very difficult. And so I've drafted a letter that I'd like passed out to the various commissioners as well as the clerk to be entered into the record, and I'll tell you where I'm going with this. What I have found, what the residents feel is going on but don't have access to within the public records, I asked our city attorney back in July to provide me in my office with all the documentation, any emails between their office and the developer and the planning and zoning department. I got back 5 emails, which was basically the final legal decision that was given by Dan Goldberg. Later, we started having doubt on this opinion within my office and started really trying to study how they came to this opinion. I'm no expert, but even from a layman's terms, I read Dan's opinion and I have trouble with it. So we did a public records request from my office to IT, asking for the exact same thing we asked from our law department, and I got dozens of emails. My city attorney has not been forthright with me and my office with all the information that I need to decide on this case. Documents were withheld from me that would have perhaps changed my decision on this case to understand how we got here. The representation of how this came to be was not straight. And so here I am, left to decide, work with the developers, work with the residents, and I don't have all the tools that I need. So in this discovery that my office was able to make through the IT department, we learned that there is another hand that's pushing this entire effort, and that is, no surprise, the lobbyist for the developer. And this is not to demonize that lobbyist or the developer. They play within the rules that are given to them. It is our job as a city, as a planning and zoning department, as a public works department, as a legal department, to know when to say no. The law says this, and this is what you do. And in this particular case, it was whether or not a warrant should be issued for this replat. It's not a big deal, but it is a big deal. And this small issue of whether or not a warrant should have been issued has escalated to this, to where I don't have the trust of my own city attorney's department anymore. So, I don't know where you all will stand on this, because you've heard many residents talk about deep into the weeds of what's wrong with this replatting. And I'm just going to give you a summary of what they're trying to tell you. But really, what I want you to understand from me is that I don't have the trust of my city attorney right now. I've lost my trust in her office to provide the documents that I request and to give me the full story that I request to know what happened. In this particular case, the Planning and Zoning Department issued a decision to a developer. They would need a warrant to go through this process. It was on a punch list. You need to have a warrant. No big deal. They fought that decision. Again, no big deal. Planning and Zoning Department stuck by their decision. This attorney then went through Victoria Mendez through a friendly relationship that they have as fellow attorneys, no big deal. Victoria Mendez then assigned an attorney to give an opinion. Her office works for this city, not for the developer and not for that attorney. No one from my office and no one from Planning and Zoning asked the law department to intervene here. The developer did. And so Ms. Mendez put Amanda Quirk on the case. Please review this, talk with the developer, see what you can find. That attorney, working under Ms. Mendez, agreed with our Planning and Zoning Department and said, this has to go to warrant. It's very clear. She made an analysis. Done. The developer pushed again. No, we think it shouldn't have to go to a warrant. Vicky, can you do something about that? And in this correspondence that I found, it doesn't look pretty. It's basically the attorney for the developer, Javier Vasquez, pushing Victoria to side with their opinion. Our attorney disagreed. So that attorney is no longer on it, and she gets another one of our attorneys until that attorney gives an opinion that agrees with the developer against our Planning and Zoning Department. And then our Planning and Zoning Department is asked to change their mind to agree with that developer. This is not the job of our law department. It's not. This is the purview of our Planning and Zoning Department that gave their decision. The proper avenue for that attorney, for that developer, and there is an avenue, is to appeal at Planning and Zoning Appeals Board, where there's a public hearing, where the public can weigh in, where all of us can see this and what's going on, and other specialists can weigh in on whether or not that Planning and Zoning Director was correct in their decision. I understand things get fluid, the attorney gets involved, a decision's made. I've been told this is the way it's always been done. That's not acceptable to me. Things have to be done by the process, they have to be done in the public. We can go through the weeds of whether or not the warrant is warranted or not, whether or not their process was correct in getting involved. But the most important thing to me is I asked my city attorney for all the emails, and she didn't give them to me. She only gave me the end little mini decision that they had come through after their entire journeys, where people in her office disagreed with the developer. I want the whole story so I can make the decision. It is absolutely not acceptable, and for me, that alone is enough that I cannot work with trust in my city attorney. And so I've written this letter to you as fellow commissioners, and I will not make a motion at this point. I think we will break for lunch, but I'll ask you to review it. I'll read it briefly into the record, and then obviously you can sit on this, because I know it's a lot. I know none of you knew this was coming at all. Due to sunshine, I have not been able to share my feelings of this week, of what I've been going through after discovering this information. And so, September 8th, esteemed colleagues, this is a difficult letter for me to write. I've lost my trust in our city attorney, Victoria Mendez, and I will be discussing her actions with you during item PH4, the Battersea Woods replatting issue. Over the past 2 commission meetings, I have taken the unusual step of moving to defer the approval of PH4, a replat in Coconut Grove labeled Battersea Woods. I have made this motion twice in a row in order to hear from my constituents who are concerned and infuriated by what to them seems to be a zoning entitlement that violates our city code. While the detailed interpretation of the code and the end decision of whether or not this replat required a warrant are important, these are not the reasons that I'm writing this letter today. Listed below are the relevant issues with regard to my loss of trust in our attorney. 1, Mrs. Mendez intervened improperly in a zoning matter in order to overrule a determination of the zoning administrator, an overreach of her position that is in opposition to our city code. 2, Mrs. Mendez ignored the opinion of experts both inside and outside her department when their findings were not favorable to the request of a lobbyist friend. This includes reassigning analysis of the issue within her department after an assistant city attorney made a finding unfavorable to the lobbyist. Mrs. Mendez mischaracterized the events related to the issue when queried by my office. Upon being asked to provide backup information to help us understand the issue, Mrs. Mendez withheld dozens of vital documents. These documents conveniently included all references to her involvement in the issue at the request of the lobbyist. I take no joy in writing this, as I am personally fond of and have had a good working relationship with Victoria thus far. However, I believe the level of impropriety that I've been able to document warrants the removal of Victoria Mendez from her position as city attorney, as well as independent inquiry into her department's policies for handling zoning matters and public records requests. Additionally, I believe it is important to consider these facts as we move once again to consider this replat. I look forward to further discussion on this issue today. Gentlemen, if you have any comments or would like to discuss this at all right now, I'm very open. Victoria, obviously, you as well. If you'd like to wait, we can break for lunch and then reconvene. Commissioner Suarez.
Wow.
I'm sorry.
I guess I wasn't expecting that with 13 minutes left to go before the end of the lunchtime, for sure. This letter obviously refers to a variety of different things, one of which is a code provision in number 1. So I'd like to see what code provision specifically you're referring to. Number one refers to a violation of a code provision. So I'd like to know what specific code provision you're referring to.
Sure.
Certainly, you also refer to a lot of documents that I can't speak for my colleagues. I don't know if they've seen any of the documents. I have not.
No, they haven't.
Seen any of the documents. So, that's something that I'd like to also take a look at and review.
I'll have full backup for you. I know it's a lot of information, and on some points you may agree with me and you may not. But in the end point, there is one thing that is absolutely indisputable, whether it was a mistake or not, whether it was by accident or not. I requested documents, and I did not get them for months. So I will pass out the documentation. I will provide all of you with backup to the analysis of the points that I've made. If there's no other comment, we shall break for lunch.
Yes.
Thank you. We'll reconvene at 3 o'clock.
Commissioners, there is a Midtown CRA meeting as well.
We'll take that up now first.
Yeah.
Okay.
Commissioner, if I could.
Yes, of course.
For the record, my name is Javi Vasquez with the law offices of Berger Singerman, and I'd like to, if I could, through the chair, to address some of your comments as my name was brought up.
Yes.
Thank you very much. So, I am the attorney of record together with my partner Paul Fig on this matter, and I would like to state for the record that I have been a practicing lawyer for 25 years now, I think 26 years, and I think I have an obligation to stand up here because there was a tone of impropriety as it relates to some of your comments. I appreciate that you made a specific comment that and I'm going to paraphrase, but that it is expected for the applicant's attorney to push for an interpretation as we see things. I've known Victoria for a long time, and at no time has there been any request for a change of attorney. At no time has there been any type of special favors. This has been a straight. As a matter of fact, this is a platting process, which typically is much more black and white than your traditional quasi-judicial matter. So I want to stand up here to defend my integrity as an attorney. I want to stand up here and defend the integrity of the law firm that I represent. And I also want to defend the integrity of my clients who have been nothing but patient. They've done everything that has been asked of them, including more than 10 meetings with the neighbors. And we feel that where the city is today, we were ready to not only corroborate with regards to Ms. Mendez's position, but as well as that of your planning and zoning department with regards to whether or not a warrant is required, is what we worked hard for, and we worked very hard to get to this moment. So I'm up here to, once again, respectfully address your comments because of the fact that you specifically called out my name, and I believe it's my obligation to clear my name, clear that of my law firm, and clear that of my client.
Thank you, Mr. Vasquez. It's a pleasure, and I do want to stress that I do not feel that you lobbying for your client is incorrect, that you shouldn't be pushing for the interpretation that you feel is correct. But I do have a question because the bulk of the emails that I found on my secondary request did come from you and to Victoria. Are you registered as a lobbyist on this project for this client?
My understanding is that I am.
My understanding is that you're not.
Okay.
I'm open to being incorrect on that, but I would like that checked.
Okay, no.
Thank you.
And we will look at it from our end as well. I've been a land use and zoning attorney and governmental attorney for many years, and that's part of the process that one of the first things that we do at our office. There's a procedure for it. My answer to your question is I believe I am.
And I do understand. I can see the fluidity that everything had happened. now that I've seen the documents. But I asked to be taken on that journey, and I was kept in the dark. Thank you.
Thank you, Commissioner.
So we shall break for lunch after the Midtown CRA. Would you guys like 5 minutes before getting to the CRA, or do you think we can do? Okay, we'll knock it out. And Commissioner Hardiman has said he'd like to reconvene at 2 p.m. For the regular commission meeting. So we'll break now for the Midtown CRA meeting.
I just need 2 minutes.
And just to be clear, Mr. Chair, I probably won't be here exactly at 2 because I thought we were going to reconvene at 3 has been our practice, so I'll probably be a little late.
We reconvene at 3.
Yeah.
Any of the commissioners are watching on television, which we tend to do when we go in the back, please make your way into the dais. As I understand right now, there's no motion on the floor, but we were considering PH4. And typically during the afternoon, we consider the planning and zoning items, and I know everyone, for the most part here, right now, came for the planning and zoning items. And so we're going to move our way through some of the regular agenda before we open up the public hearing section for the planning and zoning items, so you have an opportunity to speak and go home if that's what you wish to do. Okay? Okay. The meeting's already been called back in order. Now we have quorum. We were on PH4. I was watching. I know there was some lively discussion. And before we move on any further, I just like everyone to be aware. PH4 is the agenda item accepting the final plat of Battersea Woods. Currently, there's no motion on the floor to accept or deny that request. However, I know there was some conversation regarding our city attorney. And so before we go further into that, I want everyone to understand that parliamentary procedure, as chairman, what I'm supposed to do is guarantee that we're moving efficiently on our agenda. And if there's a will of the body for a discussion item or for a motion, that there's a motion and a second. If there's a motion and a second, then we move on with that discussion about that item, whatever it may be, on the agenda or not. And once that motion and second is made, then we'll be able to finish that discussion. But until that motion and second is made, then we're going to continue on with the irregular agenda. Okay?
Thank you, Mr. Chair.
You're recognized.
Separate from that, a few residents who did not get to speak this morning because of the new public commentary period have shown up and have some comments they'd like to make on some of the agenda items, and they were asking if we could open public commentary once again for those who did not know of the new process, who would like to speak on some of the issues on our agenda today. I don't think there's many.
What we can do, for those people who want to speak on agenda items that are for the regular agenda, can you stand to be recognized? I don't see any right now. So what we're going to do then...
I think we're all right then.
Okay. So what we're going to do then is we're going to call PH4, unless you want to make a motion and there's a second for that's consistent with what you said yesterday. We can, but like as I stated, we can move through the agenda. We can skip PH4 if you like. We can handle PH4 and move on to PH5.
I would like to defer PH4. We defer PH4. A lot of new information has come in, even in this past evening and morning, from the Planning and Zoning Department, which I believe has a new opinion on whether or not this issue should have gone through warrant. And so we'd like some more time to review that. But that does not preclude the other discussion that we had started, which I'd like to wait till my fellow commissioners are here.
Okay. So it's been properly moved. Is there a second to defer PH4?
Mr. Chairman?
Before, let us finish this. Is there a second to defer? It's been seconded by Commissioner Gort. Is there any discussion about the deferral?
Chair?
Is there a date that you want to defer to?
Next commission meeting.
Yes, sir, September 22nd.
Okay. All in favor, say aye.
Aye.
Aye. Motion passes. Yes, sir?
Good afternoon, Mr. Chairman, and I was hoping to be recognized prior to the vote. My name is Javi Vasquez. I am with the law offices of Berger Singerman, and I am the attorney for Battersea Woods LLC, which is the item that you are now talking about. I do need to clarify an issue that was discussed prior to the break. Right before we broke, Commissioner Russell asked me if I was a registered lobbyist for this matter, and I answered affirmatively. I went back, checked not only with the clerk's office, but with my office, and the misunderstanding that took place is that I am registered my annual lobbyist registration is in place, and apparently there was a misunderstanding as to whether a lobbyist registration was required for the matter, and my assistant did not file it. What I did to err on the side of caution is I did file a lobbyist registration during the break to make sure that that issue is no longer an issue. If I could also, Mr. Chairman, I'd like to address Commissioner Russell, because he did make some very significant comments having to do with my name, my firm, and I think I need to clear the air on a couple of things.
I was watching as I was in the car traveling away, so you made that exact same statement, and you did make some clarifications on the record.
Just one small additional statement, for the
If
purpose.
there's one statement, I'll give you.
And I appreciate that. So I've clarified the issue on the lobbyist registration. And again, just like I mentioned before, there was a significant tone of possible impropriety. And I want you, Commissioner Russell, to understand that when you make comments with that kind of a tone, you impact a firm that's got a very significant reputation in this town, a firm that has a significant relationship with the city of Miami, a firm that has represented the city of Miami, a firm that has done pro bono work on behalf of the city of Miami. You implicate my name. I have possible clients in this audience. I have possible clients watching this. And that tone can affect what I do for a living. This is how I make a living. And I've always made it a point to do things the right way. The fact that we've asked the law department.
Do your best to
Last point, and I will wrap it. Last point that I was not able to make. The fact that we asked, through the submittal of a legal memorandum, the law department, for a reconsideration on a position is very normal and very ordinary in the course of what we do when we're trying to advance the position of clients like Battersea Woods. It sounds like you've deferred the item. We were prepared to continue our presentation today. Mr. Paul Fig, who presented before you July 29th, is here. But again, it is very important, sir. Not sure what the direction of your conversation was, but it's very important that you please, and I'm asking you on the record, clear that record, because you're putting a lot of reputations at stake, and it's not fair.
Mr. Chair?
You recognize.
I absolutely will do so now, and I thought I was clear when I spoke that I do not implicate your firm.
Thank you, sir.
For doing anything but advocating for your client.
Thank you.
And that you didn't do so in an improper way.
Thank you, sir.
The only question I had was with regard to the registration as a lobbyist on this issue, and I understand that you now are.
Thank you,
and
sir.
I appreciate that. But
And I apologize
if
for the
my tone was
misunderstanding.
misread, I apologize for that.
Thank you, sir.
All right, thank you very much. PH5?
Mr. Chair?
Yes.
If I were to like to continue the discussion that I began before this, would you need for me to make a motion?
I would need for you to make a motion, and there need to be a second, so we have a direction in which we're going, and not us just having to talk, and there's no support for that discussion moving forward. So if you'd like to make a motion, it would require a second for us to continue that discussion, because as I understand, the motion would be to remove the city attorney from our position.
That is my motion. I move that we remove the city attorney.
Okay. That's the motion. Is there a second?
Second for discussion, and I wish the motion would have been to discuss.
But this is what the reason I say this is this: you don't want to spend 2 hours discussing something that you have no intention of doing. If there is an intent, clearly there's an intent by the mover. I'm hoping that there's some genuineness in the second, so that we have a discussion. And I'm assuming that the discussion would not be just to talk about a lawyer's reputation, because we have to understand that when you make implications about a lawyer, which is why he's standing the way he is today, It goes much deeper than the job that person has today. It goes into their Florida bar status. You have a lot of different people who watch these types of events, and bar complaints that could significantly deter, if you will, that lawyer's path, and sometimes remove them from practicing law. So being a lawyer is a privilege, and so I want to ensure that we protect that privilege by giving us an opportunity to have a serious discussion if we're going to move towards this way. But I don't want to have any discussion about something that none of us, if there are some of us, are not serious about having. So I think this is a very serious matter, and so if we want to have that discussion, then I want the movement to be sincere, and then we go into our discussion about the matter that I'm sure each of us will be arguing from our points of view.
Mr. Chair?
Yes.
My motion is very sincere. I do, of course, reserve the right, upon further discussion and understanding where my fellow commissioners are, to amend that motion.
Mr.
There's a
Chairman,
motion. Do you stand on your second?
Mr. Chairman,
Yes.
I want to begin by saying that I don't have any predetermined outcome of any of this, so I don't know as far as intent, what intent I have, other than if one of my colleagues has an issue, and I think we all can reach consensus that it's an important one, I think we should hear him out. I can tell you this, I haven't even had the chance to read all these documents that he presented.
That may
So
be
I
another
have no
reason.
intent to do one thing one way or another, other than listen to my colleague that obviously has an issue.
No, which I'm saying. So, I mean, you can take that in two ways. The fact that you haven't read the documents can mean that maybe you don't want to have the discussion because you want to be prepared for the discussion. Or you can say, no, I'd rather go through the discussion right now, and so you have a second. If you have a second, you have a second. I'm not going, as the chair, I can't take away your ability to make a second. It's either a motion and a second, and then we go for discussion.
Right, and
So do you have a second?
I did mention a second, and that's when you started mentioning as far as being sincere.
So
And I'm saying that the only way that we could discuss this if I make a second. Therefore, I'm making a second so we could discuss it.
So it's been properly moved and seconded, discussion.
Can I make a recommendation? Whoever wants to make any decisions on something of this severity needs to read the documents that Commissioner Russell kindly distributed to all of us prior to the lunch session. That, thank you. I think because that provides context to some of the, to his letter, first of all. It really should be sort of an addendum to your letter, an attachment to your letter, or whatever the case may be. The other thing I never got, and this may be it, I'm not sure. Is this the?
This is further documentation that was meant to
Okay.
be included this morning.
Because I did ask prior to lunch.
That's
there's-
what this is.
Is that what this is?
Yes.
Because prior to lunch, there's a reference in number 1 of the letter that says Ms. Mendez intervened improperly, blah, 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 blah. All the way to the end, it says in opposition to our city code. And so I was trying to figure out which part of the city code you were referring to. So I haven't had a chance to look at this.
I understand.
I just got it. So, I respectfully suggest that any decision of this magnitude be done fully informed, but, it's up to you guys.
There is one issue that is not in dispute from the city attorney or myself, and that is that I did request public documents that were under her care that were not delivered to me. Whether the intent of that is that it was a mistake or intentional is not even being measured or discussed here. The fact is that I made a public records request to her office. A huge majority of very important documents relevant to this case were held from me, and I found them later through an IT search, and she admits that they were not given to me, but says that it was a mistake rather than intentional.
Can I ask a question?
Of course.
Another thing, was that a verbal public records request, or was
No,
that a written?
it is absolutely written, and it is in the first page. Madam City Attorney, this is July 25th, in anticipation of hearing this item on
But
Friday.
I don't know, wait, hold on, I don't know where you're reading.
I actually don't. I don't believe this. My request to her is in your documents. I can copy that right now for.
That's something that I would want to see as well. I mean,
Let me read it to you right now. We will be meeting with the owner of the property. Can you please provide us with the email exchanges between your office, the planning department, and the property owner's attorney that have to do with whether a warrant was required or not in this replat? And the response I got were these 5 emails. When I did the IT search on the same basic criteria, emails between the attorney for the developer,
Right.
our city attorney's office, and the planning and zoning department, we got back 1,600 emails, which we went through, and several dozen were very relevant to this case, and actually showing the relationship on how the city attorney's office injected themselves into this situation, in my opinion, incorrectly. The main reason that I'm asking for her removal is not for the opinion that was given, which further documentation will show that even though the final opinion that was given by Dan Goldberg, he even says, I don't agree with my own opinion early on, and his mind was changed. That's not the reason. The reason I'm asking for her removal is with regard to my trust for her to provide documents to me that I need to do my job, much less public records from a resident or a constituent. Within our offices, when we ask our city attorney to give us the documents we need to do our job, and to tell me, not only the documents, tell me the story, so I'm up to speed, and she leaves out everything up to the final decision that coincides with the decision, with the opinion of the developer. There was a lot leading up to that I needed to know, and I was not given that information.
And the question I'm asking is, I haven't been given the information of your request, and that's the question I have, because not that I don't agree with your characterization of your request, I just haven't seen it and haven't read it. It wasn't part of the package, so I'd like to see it. Thanks.
Commissioner Gort?
I think we should make a copy.
Let me tell you, one of the things I hear from lawyers all the time, and especially from our office, is everybody's entitled to due process. I think this motion here is not a due process. I think a lot of the information you have received, and then one advice I give all of you, anytime I have anyone asking for public information, I send them automatically to IT, because I don't have that many information in my computer. So I make sure they get it all from IT to make sure if I miss something, they already have it. So I understand your emotion, you gotta be very upset, and I agree with that, but I think the due process should take place. I don't think this is a place right now to do that, personally.
He's making a copy of that.
Thank you.
Of that email.
So as stated before, there's a motion and a second on the floor to remove the city attorney from office. We are in discussion. Of course, there's some unreadiness. The unreadiness has been stated on behalf of Commissioner Gort and also Commissioner Suarez. And so we're just...
Mr. Chairman?
Yes.
I mean, I could tell you, I have unreadiness on voting on removing her right now. I mean, we still haven't fully, at least I haven't fully read this, and we haven't fully, even done due process. I haven't even heard from Ms. Mendez, and I don't know if now this is the right time or not, but like I said, at the very least, if one of my colleagues wants to have discussion on this, absolutely.
Right.
And in order to do that, you wanted a second, so that's why
That's why I made I made the
Exactly.
original motion instead of simply
Exactly.
having a discussion.
Exactly.
And I understand. Recognizing the unreadiness amongst the commission, and I see that. And I do understand, due process is important. I made the motion simply to begin the conversation. I am very sincere in it, and I believe that you will see my side of this once you review all the documentation. I'd like to hear from my fellow commissioners on what they think might be a proper process to move forward. We could ask for an independent investigation to review the documents, or we can do it ourselves as commissioners and reconvene. I can put a discussion item on the next City Commission agenda to take this up at that time. Which way would you like to do it?
This is interesting. It's interesting because typically there's a lawyer-client privilege. And so when you ask about an independent investigation into your lawyer-client relationship, that's just a very unusual thing in my eyes that you're asking for. In regards to the motion on the floor, there's two ways that you come to a vote. I mean, you have discussion, you influence other commissioners to see things your way, and you have a vote. The unreadiness comes because someone's not ready to vote. So there's more discussion that needs to be had. And the question really comes to will, after all discussion that we have today, if we sat here for 4 hours and discussed this, or 3 hours or 2, will we be ready to vote at the end of it? And so I think that's the question that we really have to ask ourselves, is getting the information as you have it today, enough time to come through and make a decision that you think is wise in this case.
I mean, I think there's also, and I don't know if this goes to the independentness of some of the information that's needed, but there is the city attorney, unlike the city manager, has a charter mandated period of time or office time. And so I don't know, even though the contract is very clear, because I did ask for the contract in the break, and the contract is very clear that there is a provision for essentially termination at will or for convenience. I'm not sure how that interplays with the charter provision that requires the city attorney's office to be, that there's a term, in other words. So I don't know whether we would need an independent person to give us some legal advice on that issue, because that's an issue that, I'm not a constitutional scholar per se, even though you guys put me on the Charter Review Committee. But that's certainly, I think, an issue that needs to be, we need to get some advice on. Because you definitely have language in the contract that says one thing, and the charter says something else. And, typically charters and constitutions trump documents, so, contractual documents. So there has to be some determination that, or some, I think, analysis of that issue, because I think that's a real issue.
And maybe differences of opinion on that, on what's right. Yes.
I have reviewed that, and the charter does, and the resolution appointing Mrs. Mendez absolutely says exactly what Commissioner Suarez says, that she will serve until the first City Commission meeting following the next general municipal or runoff election, which implies a term.
Right.
But I don't believe, and especially as termed in her contract, that any of us understanding the position of the city attorney and the other positions, they serve at the will of this body. And 3 votes is all that would be needed to remove them. The contract even has severance package stipulations, which obviously imply the possibility that they could be fired.
Well,
I think the contract clearly contemplates it. I don't think the contract does, if I may, Mr. Chair.
Please.
I think the contract clearly contemplates that for the manager and for the city attorney. I'm just saying, and I think this is this section 21 of the charter? So this is section 21 of the charter, and that says the city attorney shall be a full-time government employee, shall not engage in the, yada, 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 and shall serve until the time for the election of the city official specified in section 4, which follows the next general municipal election. So I'm not so sure that provision of the charter can be trumped by some subsequent either resolution or contract. Mm-hmm. So that's what I need clarity on. And obviously, it's hard to get clarity in a, you walked away. You said there was 13 minutes left. It was like 12:47, and you said, you think we can get a couple things done before lunchtime, and you left. And this, this sort of happened after. So, these are issues that sort of flood in as you try to get up to speed, because I didn't know where this was going to go post-lunch. So I wanted to get as prepared as possible, but simple things like obviously the statute that I asked for, and also your request, which I think is important. Your request is very important. The request that you made in terms of, because that's really what you're basing a lot of your issue with, which is because I take public records very seriously. I think we all do, but I'm saying I know that when I get a public records request, I try to the extent that I can, I try to provide it as quickly as possible. I've even had some people that are very critical of us and me sort of acknowledge that. But so that I take extremely seriously, and that's a big deal for me. That's why I wanted to see what your request was specifically.
I mean, I know there's a lot of information for us to digest regarding the issue, and because I know that I have so much unreadiness about it, the only way that I could vote would be against, because there's no way that in the time that we have here allotted and with the agenda today and how this popped up, that I would be able to make a decision. I'm still getting more information about what's happening. So, I mean, I have an unreadiness
And
as
Mr.
well.
Chair, I do apologize for dropping so much on our commission at one time with such a surprise, so to speak. This is all quite new for me as well. And so, obviously not being able to speak with you before today, most of this was collected in the last few days. I would be willing to withdraw or defer my motion based on a solid concept that we have moving forward on how we're going to handle this. If we can at least address that today, whether we believe we should have a special commission meeting for this issue specifically, whether we should just put it as an item on the next agenda, and whether or not we should have external help in analyzing this. That would be my opinion, because I really think a fresh pair of eyes looking at our charter, for example, as well as the trail of information and the accusation that I've made, whether it's warranted, after that, they will advise us and we will make our independent decision if the charter allows it.
You know, for me personally, you know, I depend on my city attorney to give me an opinion about things. And sometimes she gives me an opinion that I don't necessarily agree with. And I push back and I give her the reason why I think that it is different. Mm-hmm. Every day that we handle a planning and zoning issue, there's an attorney that says one thing and then another attorney who has the exact same facts that says something else. And it happens all the time in criminal court as well. One attorney says that they met a burden, the other one says they did not. And so it goes all the way down to motions. And so, you know, having, you know, I trust that even without Ms. Mendez being the attorney who gives an opinion, that her office could handle giving an opinion in this whole matter. And I don't think it is necessary that you go outside for someone to interject themselves in that lawyer-client relationship, because at the end of the day, that's one of the things that I think about. What information are you now putting out to the public? Not saying that the public isn't due to information, but you have to understand that when you have a lawyer-client relationship and your lawyer represents you, that you have a special relationship that's not shared with other people. And so, you know, for me, I think it would probably be best if you put it, if you were going to have if you wanted this to be something that we address on an agenda item, put it on the agenda and put all your support attached to it, rather than hiring some outside counsel. This is my opinion. Hire outside counsel to
Mr. Chair,
research themselves.
With all due respect, Mr. Chair, I really don't think that we can get an unbiased opinion from our own attorney's office about whether or not we should fire our own attorney.
Not about that. No. That's a conclusion that you come to.
But even the analysis of the documents.
Well, that's what I'm saying. So this is what I'm saying to you. The conclusion that you've come to is that the city attorney needs to be removed of her duties. The opinions that were differing, as I understand, were one, do they need a warrant process or do they not need a warrant process? And in the city attorney's office, where you have, I don't know how many, you probably have at least, how many attorneys
28.
do you have? 28 attorneys. If you have 28 attorneys in the city attorney's office, you got 30 different opinions. Because a couple of different attorneys may have two opinions depending on which way the tide, comes in. And so I say that to you to say, even in a judge's courtroom, when a judge has given an opinion about something, his law clerks may say, Judge, it's this. This is the opinion that you should come to. And the judge may say, no, it's that. And so write an opinion on that. And so I'm saying it to say, it doesn't surprise me that lawyers have differences of opinions about the same issue. And when the lawyer gives you their advice, the legal advice, that's all that it is. It's us who come and we make the decision based off of the lawyer's advice. And so, for instance, I'll give you, so that's, for instance, when I would get a little frustrated when I don't feel like I got the advice that I was asking for. If I get it depends. Well, I'm not asking you for, it depends. I'm asking you for an opinion. But it truly does depend. And so what I'm saying to you is that when there's a difference of opinion in attorneys, it's not surprising to me. And it doesn't jump to it doesn't move me to the part where you say, okay, well, this person needs to be removed from office.
Mr. Chair?
Yes.
My point is that no attorney should have been working on this unless they were requested to by a member of the city. And they were not. And so when the attorney for the developer asked the attorney's involvement, this was the decision of the planning and zoning administrator. And they issued an opinion. And the legal department was brought in, our legal department was brought in by another attorney to overrule that decision or change their mind. And in the end, and one of the latest emails that I've just brought to you that was just passed out with that one part of the code is where Attorney Goldberg from our office is saying to Victoria Mendez that he can't seem to convince our own zoning administrator to change his mind. He says, I can lead a horse to water, but I can't seem to make him drink. The pressure was on our
Well, that's
zoning
not really,
administrator to change his mind. And that was coming from our law department, who was not invited to participate in this other than their relationship with the attorney. I'm not saying that relationship is inappropriate. They can ask, they can be friends, they can go to lunch, everything. But at some point, this is the purview of our zoning administrator. The fact that they got involved, they got multiple opinions. They kept moving until they got the opinion that matched with the attorney for the developer. This all speaks to the fact that it was done incorrectly. I believe that the zoning administrator should have been left alone on their decision, and if they wanted to appeal that decision, they should have sent it to PZAB.
Okay.
Mr. Chair.
I'm going to call you, but Mr. City Manager, we're going to get to you. Mr. City Manager, Danny, is there an attorney from the city attorney's office that is put on the at the time, what was the
Planning and Zoning and
Planning and
Appeals
Zoning?
Board?
Is
PZAB?
it Planning, Zoning, and Appeals Board? Is there an attorney from the city attorney's office that sits on there that gives opinions towards things?
Yes.
Okay. Now, I was just asking that because I wanted to know if a city attorney or the city attorney's office was actually involved on a board helping to make decisions. Francisco, Commissioner, and then I'll let this gentleman call.
Thank you, sir. Francisco Garcia, Planning and Zoning Director. There is an attorney, and there has been over the years, there have been a number of attorneys, but the city attorney's office does designate an attorney, in some instances two attorneys that alternate to assist us, the Planning and Zoning Department, with questions pertaining to items going before the Planning, Zoning, and Appeals Board, and that attorney also, or those attorneys also, serve in an advisory role to the Planning, Zoning, and Appeals Board.
So it's not unusual for an attorney or the city attorney's office to have an opinion about an issue that's before PZAB.
Upon request, of course, they have always provided us counsel.
Commissioner?
Yeah, I guess there's a couple things here that merit further investigation and further sort of understanding. One of the things is again, obviously we got this right before lunch. I obviously tried to look at the documents during lunchtime. I noticed that most of the documents predate you as commissioner. And so the relationship between the administration and the city attorney and a commissioner, for example, it's a different relationship as far as I know constitutionally. In other words, we as commissioners do not have the authority to direct a member of the administration or a member of staff. I believe that relationship is different with the city attorney because the city attorney responds directly to the commission and is responsive to the commission. So for example, I believe that a city commissioner could ask the city attorney to get involved in something, and that would not be direction. I don't know whether to ask her or not because, clearly this is something that involves her, which highlights sort of my second concern, which is I do unfortunately agree, that we do need independent advice. I do, because, I think the question that I came up with relation to the charter issue, and if I want to ask somebody a question on an interpretational issue of the charter, who am I going to ask? I mean, I have a question. That was the question that I had.
You're a counsel.
Well, right, but in essence, that's the person who we're talking about. So I think that's sort of the inherent problem that the commissioner has an issue with, and that is understandable. I mean, we do that. She does that, and we respect her when she does that on a variety of issues when there's potential conflict. So, that's that part for me is something that's problematic.
Well, I think we can really go into the weeds on whether or not a warrant was necessary and whether or not the law department should have injected themselves. But I don't think there's any dispute on the fact that I requested documents and they were withheld from me, and for several months. And to me, that's enough in itself.
Madam City Attorney, I'm sorry.
Yes, I need to respond to that because basically nothing was withheld. Absolutely nothing was withheld. What happened was on July 25th, Eleazar Melendez asked me for information, which you have in a document before you. In anticipation of a hearing on Friday, we will be meeting with the owner of the property. Can you please provide us with the email exchanges between your office, the planning department, and the property owner's attorney that have to do with whether a warrant was required or not on this replat? I'd like to have it ready beforehand. Thank you, Eleazar Melendez. So I called Eleazar because your meeting was the next day. This was at 8:02 p.m. I think your meeting was at Tuesday or Wednesday with the developer. And I asked him, okay, what is it that you're looking for? Because if I have to do an IT search on all these things, you're not gonna have it by tomorrow or the next day. That's when he told me he wanted the opinion that my office had drafted to opposing counsel on this issue, because I believe he was meeting with the developers or opposing counsel. And please interject whenever. At that point, I did a search, Danny Goldberg did a search, and we got our emails that we found on that issue, and we submitted those to you. What I should have done is written back and say, I'll give you whatever preliminary documents I have, you have to run an IT search. That's what probably I should have done. But I gave him the documents that I had, the documents that I remembered, the ones that you ran a more expansive search, giving terms, Javier Vasquez, Victoria Mendez, Palm Corp, or I don't know, Carlos, or, all these different, and then you got a really expansive search because it was an IT search, which is what I originally mentioned should have been done. So, and it's really, it's an odd situation because the way I understood it is give me what you have, and I turned over what I had in anticipation of the meeting that you were gonna have on this issue. So nothing was withheld. These emails took place a year before. I deal with thousands of issues on a daily basis for this city, thousands. If you thought that I remembered who handled this issue a year and a half ago, I didn't remember if Amanda was on it, Danny Goldberg, myself. So, I'm sorry that you feel this way, that I've withheld something from you, but that is not my intention. I know the public records law. I know how many people sue on the public records law, and IT doesn't lie. So whatever is placed, in a document, that's nothing that I would withhold. And the same way that you did this research now, which you asked for a full comprehensive one, that could have been done back then. But I was just giving you the information that you needed immediately for your meeting, which whatever documents you found would not change my opinion. And I know you don't like my opinion. It would not change my opinion. And I'm sorry about that.
I want to recognize first the gentleman because I know you've been waiting to speak.
I'm going to be incredibly brief, and I'm not even going to talk about PH4. I only want to say something because it's relevant to what's occurred here, and it's been repeated many times. Carlos Tosca, 6844 Sunrise Court. The city attorney's office did not inject themselves into this decision. The zoning department, which initially said we did not need a warrant, and we went through the T-Plat process without a need for a warrant, later on added the warrant. We questioned the zoning department, and when they said, look, this is already a matter of interpretation of law, they sent us to the legal department. The zoning department, exactly what you said should happen, is what happened. They sent us to the legal department, and the legal department vehemently defended the city's position against us, like they're supposed to do, and we did our part. This is what cities and attorneys do. They argue until somebody convinces the other one. So while there's been an incredible interpretation of impropriety, there was no impropriety whatsoever. And unfortunately, that's not going to be able to be settled now. A lot of people left. A lot of things were said that won't be cleared up, but that's the reality. We were sent by planning and zoning, and I'm sure that they'll confirm that. That's a matter of record as well.
Thank you very much.
Mr. Chair.
Vice Chairman, do you want your staff member to speak?
In just a moment, I just simply wanted to respond to that, because if that's the case, my records are completely incorrect, because my email was from Javi Vasquez to Ms. Ellis and Mr. Cejas saying, thank you so much for meeting with us about the above referenced plat, whether or not they need a warrant. We have respectfully asked for the opportunity to discuss the warrant requirement with your legal department. That is you requesting our legal department's involvement, not you being sent to our legal department.
We had a meeting with them, and in the meeting, they said, if you want a different interpretation, you've got to go to the legal department. And then we sent a formal request. They were in the meeting. I don't think that anybody's going to dispute that they told us that. And by the way, it's not the first time. It's normal for the zoning department to send tricky issues to the city attorney's department for interpretation. It's not a unique event. There was nothing sinister that we went to seek out.
Nothing sinister is implied on your part.
This is normal.
Absolutely not.
I mean, this is a normal process of the city. The zoning department sometimes needs the city attorney's interpretation on tricky matters, which this obviously is. So, you know, we didn't do what you're saying we did. We just didn't do it. That's the bottom line.
That's all I have in the record, but I would
Not
like,
every-
I
not
believe you
everything's
wanted
done
to
by email.
respond to
Yes.
Mrs. Mendez.
Hi, good afternoon. Eliasar Melendez, Office of Commissioner Ken Russell. I just want to respond to that because, unfortunately, the conversation as described by the city attorney did not occur in that manner. I asked for all the documents that her office had related to this issue. I did express that it was because I was meeting with the developers on the issue of the plat, but I asked for everything that her office had, and she only gave me the documents where Dan Goldberg was essentially the person that was involved. So there was no reason why, I don't know why she didn't give me the ones where she was involved doing the same thing.
Mr. Melendez, you're an experienced journalist, right?
Yes, sir.
And you've done public records requests to the city government before, correct?
Yes, sir.
And when you made those public records requests to the government, you used probably very specific language in that request to note that it was a public records request, correct?
Yes, sir. So that it would prioritize.
Right, because you want to be able to get that public records request, or if not, be able to have some actionable way of saying that the city did not respond correctly to your public records request, correct? And this email that you sent, where you said, in anticipation of hearing this item on Friday, we'll be meeting with the owner of the property. Can you please provide us with the email exchange between your office and planning department and the property owner's attorney that have to do with whether a warrant was required or not on this replat? I'd like to have it ready beforehand. You didn't use any language in here that talks about public records requests, did you?
No, sir.
Right, and so if you did not use that, I'm not going to ask you a conclusory statement as if why would you think that someone would give you a public records request type answer, because I'm saying this for all of us to note, to make a note that when you ask your attorney a question, your attorney is going to give you an answer. And if you want a specific answer, I just suggest that you use very specific language, the same way you would use it if you were a member of the public asking for public records requests. And I'm saying that to you because the city attorney is the commissioner's counsel.
Mm-hmm.
And so I wouldn't expect to trip my counsel up. I would expect for my counsel to try to help me with my decision making. And when I see the facts, that's what it seems like from your email. Now, had you written, like we get from many other places, pursuant to Florida statute, such and such, I hereby request that you give me all public records information regarding this issue and that issue, these words and those key words, within a reasonable time. And then, of course, our officers, I tend not to try to get involved with the nitty-gritty of that because this kind of stuff, I send mine to the city attorney's office, I send it to the clerk's office, and I haven't quite mastered the IT. I think they usually bring in the IT to the city clerk's office. And so that's what I tend to do when someone sends a request to me. And I'm saying that not to say to you that what you did was wrong. I'm saying what you did was normal. It was what I would have done to ask for information from my city attorney. But it's much different than a public records request.
Wait,
Mr. Chair.
Sorry.
Vice Chairman.
I do respectfully disagree both with that statement as well as what Ms. Mendez said with regard to this request. I don't think it could be any more clear and in plain English and thorough. And the request that was made through IT was simply the IT version of this exact email. The question is, can you please provide the email exchanges between your office, the law department, the planning department, and the property owner's attorney? And when we did the IT search, we simply used the addresses of the people. Actually, we didn't even use the addresses of the attorneys, did we?
Correct.
But we did list the addresses that we know to be the email addresses of the property owner's attorney. So there was no difference between the IT request we made, which we only made months later, realizing that we felt there were holes in this story. Because beyond the records request, I've had many meetings with the city attorney where I wanted this story from the start. And there were many opinions leading up to this. There was a whole story going on, and she just kept saying, you just don't like our opinion.
The only opinion that matters is mine at the end of the day.
Please, Madam City Attorney, if all of this that happened before I came into office, if you had taken me on this journey when I said, walk me through this story, I'm voting on this at City Hall, I need all the information, and you walked me on that journey. Well, here's where planning and zoning was, and here's where the other attorney was, and we had some disagreements within our office, but this is the opinion we came out with. Planning and zoning eventually went this way. We would not be here today, because I would know the whole story. I may disagree, absolutely, wouldn't be a problem. The fact that I was not given the story that I asked for is what I have the biggest problem with.
Mr. Chair?
before I call you Commissioner Suarez, I do want to make one statement. The only person that can come and clarify to what they searched for, it would be the IT director. That person or whoever was working on it.
I've got
within
that
IT.
request actually.
No. What I'm saying is from the IT department to say this is what I did, how I did it, things of that nature. And all that I was trying to make very known is that anytime I've asked for a public records request, or someone has asked for it from me, I mean, they send and this is a copy of it. This is Stephen Herbert's. I believe he's an attorney that asked for a public records request from the city. I mean, and the emails are very specific as far as Chapter 119 and what he's asking for, and then et cetera. And it's much longer than that email that was there. And all I'm saying is this, is that if you have an IT director here to say, listen, I did a more expansive search. Your testimony was that you pulled up thousands of emails and a couple dozen were related. So that means it has to mean, I would think, that the search would have been more expansive than what was done, of course, by the city attorney, Commissioner
Yeah,
Suarez.
I guess my question is, again, this is obviously getting information in pieces. This question that was presented to the city attorney and to her surrogate, was this also, did you make a request in writing to IT? Is there also a request?
Yes.
Because I don't have that. Is
Yes,
there?
sir? Where'd he go?
Is there? Yeah. Thanks.
I'll get that for you. It shows the exact search terms.
Got
And
it.
the reason it was more expansive, it didn't limit it to the word warrant, where in my email to her it was said whether a warrant was required or not. So we got other emails where they were going to lunch or working on a panel or completely unrelated that I didn't include in this packet because they're obviously not relevant.
Mr. Chairman, if I could, just one more point of clarification. I just went through the emails. Every time an email is included, the entire chain before it is included. There is a repetition in that package that if we were to eliminate the repetition side of it, that package would be reduced by 200%. It would
You would
be
find a
1/3.
couple
It would be-
dozen. My statement was a couple dozen. There's a couple
Yeah,
dozen
and
email
there's not
exchanges.
1,600 emails in there. I just want to make it, again, all tone, that's what this is all about. And that's what concerns me. I'm thoroughly disappointed that this was deferred
1,600
today.
does not imply impropriety.
Okay.
That's simply
No, I know, but it's still an exaggeration beyond.
That's actually the specific number
you're
of what
including
was
repetitions. You're counting emails over and over again,
Yeah,
many times.
What he's saying is that in the 1,600 number, that's the chain of
Yeah.
each single email. Because if somebody replies, and it's the whole chain, and then
At
you're
least 7 times.
It's a multiplication. You're
Right.
multiplying.
So when I said there's a couple dozen here versus the 5 separate emails that I got, the couple dozen is the relevant number. And it may look like more because when you stack it because of the threads, each time somebody responds, their emails from
That is
before, there are a couple dozen emails in here that I was not given to make my decision on.
When you
Barb,
say
this-
couple dozen, is that 6? Is that 12?
Couple
is that
dozen is 24.
24 emails.
So,
a couple dozen.
is it a baker's dozen?
No, baker's dozen is something else. But a couple dozen is 24.
We're still having this discussion, and the question is there enough discussion today that will make us come to a decision? I think that's what, as a board, we have to come to a conclusion about. I know I expressed my readiness because of the things, and we're still learning more information. Commissioner Gore has expressed some readiness. Commissioner Suarez has as well. And so the question is, are we going to continue down this path of discussing this, or are we going to allow our unreadiness to signify that we're not ready to take a vote on this matter and we should move on with other business?
I will withdraw my motion and move that we hire an independent investigator to study this, whether it's a third-party attorney without conflicts, and that we set an item on our next agenda to discuss it.
There's your motion. Is there a second?
Second for discussion.
Okay. So we know the initial motion was withdrawn. We have a motion that has been moved and seconded. For clarification, when you say study this issue, particularly what issue do you want that attorney to look into?
If I may, I have a suggestion that'll save the city money, and submit this impropriety, as you describe it, to the Commission on Ethics. They have an investigator. Let them do it. Saves the city money. You get your investigation.
I'd prefer an independent legal opinion. I think there are ethics issues here, but that's, what we're dealing with is with regard to the code and who should be involved in planning and zoning matters. At the end of the day, our decision will be made regardless of whatever that person says. If the four of you truly believe that I was not given the information that I requested specifically, and months passed and I still didn't and had to find it on my own, and that's enough to warrant replacing Mrs. Mendez, then our decision will be made. If you all feel that that's not a serious enough infraction or that it was just a misunderstanding or mistake, I will be outvoted. But I'm telling you now that my trust in this system is broken. And so whatever method that you all would like to work together to come to better understand the points that I've raised and go through these documents, and I'm sure you're going to do it on your own as well, I am open to. So that is my motion. I'm open to an amendment, whether it's the Commission on Ethics or an independent attorney who would probably be more versed in the specifics of what's put before them. It's not simply an ethics issue.
I mean, just discussion.
Well, I mean, he seconded it. I don't want to get jumped.
He seconded the discussion.
Yeah, I mean, it's open for all of us to discuss.
Right.
It's a will of this commission, but I want to make sure that at the very least, and listen, it's nothing new. Since the first day that I've come here, I've always said, you know what, discussion, debate is good, it's healthy. And whether you voted up or down, I think we should have debate and we should have discussion. Something that I want to mention is, as far as independent, what will be the cost, what will be the cap? We need to put some type of cap to it, so it's not, a fishing expedition either, and so forth. So I want to make sure that we have some parameters in what you're requesting for.
All they would look through is a couple dozen emails, a timeline of history of how we got to where we are, and give us their opinion on any impropriety.
Commissioner Suarez?
I think it's a little more than that.
Okay.
Because you're going to have to interview witnesses. You're going to have to interview people, right? Because there's been some...
Take depositions.
You're going to have to interview people. You're going to have to take statements from people to see who said what. We're also going to have to decide who that person is. I think we've hired at least once or so. In fact, I think we hired your firm once to do an independent, to be our independent counsel. We hired Berger Singerman one time. I forget what it was. Whether
Pro
it was something,
bono.
something. I'm
It
sorry?
was pro bono. Berger Singerman
It was pro
provided
bono.
it was
We've
pro
had
bono.
we've had a few. Was that on something with the mayor?
Actually, I'm the one who made that request
Right.
of them and Mr. Berger. So I was the one who made that request.
Right.
If he would act pro bono, but as far as I know, I don't think the vice chairman is making any implication with regards to the firm.
No. That's not what I'm saying. That's not what I'm saying either. What I'm saying is that we need to pick the person, whoever that person is. That's another decision that we have to make.
Mr. Chairman, I wanted to clear, just crystal clear, that was a pro bono representation. The other issue is, in the meantime, we're talking about due process. I'd like to know, the one that's getting dragged in this process is my client on an application that got deferred again unnecessarily today. What does this conversation do with regards to my client? When does our item get heard? We are confident. You were saying that your zoning chief official was prepared to give an opinion. We're confident that that opinion is going to be in our favor. But now what I need to know is, when do we get heard? We've been deferred twice now over an issue that, unfortunately, 3 times. Unfortunately, it's not their, it's an issue with the commissioner and his attorney, and I respect that. But my client's getting dragged. And
Right now-
I think we need to talk about due process.
Well, right now, your item has been deferred to the next commission meeting. So that's the date that it's on to be heard.
What is that date, please?
September 22nd.
So the discussion on the floor right now is the motion that was made and seconded, made by the vice chairman and seconded by Commissioner Carollo. And I just want to be very clear about the motion. The motion is to, but is it more proper to play it back, because I don't want to mess this one up.
But I need some clarity on the motion, because
That's what I'm asking for now.
Right.
Can you repeat? Can you play the commissioner's motion so we're very clear? You don't have playback?
We would have to stop the meeting and then transfer the audio.
He can re-articulate.
Notes? Did you take notes of it?
No, he can re-articulate his motion.
Okay, I just wanted to be clear. I didn't want anybody to stumble over the motion. That's all.
So, but I have a question on the motion because I think there's two aspects to this. One is there's some legal questions that I have. For example, some of the ones that I've articulated, I don't know who I would go to if it wasn't an independent lawyer. So that I agree with. An independent investigation is it's a whole different story. That's what I was trying to get at, which is that involves an investigation. That's not just, we need a different lawyer that we can ask legal questions to. We could either do the investigation, in other words, we could ask all the relevant actors to come up and testify as to what was said and what was done, right? Mm-hmm. And then we can have an independent lawyer that we can ask questions to, like, hey, how does this interplay with the contract and this and that, and that kind of stuff. So there's two things at play here, and that's the part that for me is a little bit complicated and a little convoluted.
For me, I would amend my motion to the latter. If that would actually save a lot of cost to the city, make it a lot less rigorous, and we would have access to an independent lawyer who can help us interpret what we're looking at here.
Okay, so that's a different thing, because to have an independent investigator, an investigation like a special prosecutor or something, I mean it's very involved.
Mm-hmm. So can you repeat the motion so that the mover and the second are clear?
Sure. My motion is that we hire an independent attorney to help us, 5 commissioners, weigh this information. It would not trigger a full investigation in which this attorney is going carte blanche to do subpoenas and such.
When you say this information, I want to be clear, you're talking about the emails that you received, the law?
And the information I've presented to you all today.
Now, but I think that even an email, if you got an email from someone, you still would need to question the person that sent the email, the person that did the search, those things of that nature. I don't think just
and they'd have that ability at our request.
And I give you an example why, because, for instance, when the city attorney received the request, she stated that she called Mr. Melendez, and there was a conversation. So that's not captured in an email. So I think there are a lot of things that you also have to add to it if you're going to really get to the bottom of what you're searching for.
Mr. Chair?
Yes.
I have another question, which is also a legal question. I've never taken the position personally, and everybody has their own way of doing their business. I've never taken the position personally that someone has to formally ask me for a public records request with like Chapter 119 and with all that citation just to get like for me, if anyone asks me a question that relates to a public record, to me, I've considered that a public records request. So I'd love to have some legal guidance on that issue too, because I don't have any guidance on that issue.
We're not citizens approaching a governmental office. We're working with our attorney, right. And it doesn't matter whether I said pretty please or what format I put it in. I made a request and it was clear, and that information wasn't given to me.
Well, yeah, but what I'm getting at is, again, legal guidance on whether or not a public records request has to be made formally or not. I've never taken the position that it does, but I'd like to know.
It does.
Hey, if she has a legal reason she didn't need to give it to me, fine, fair enough. I still wouldn't want to work with her after that point.
Understood. And you're entitled to that. And you're entitled to that. I get it. I think, again, that goes to some of the questions that I have in terms of what happened here.
This is the IT request.
I got it.
And so, even from here, and I'm going to call on you, Commissioner Gore, even from here, you have to ask the IT director, did he do anything more expensive than this?
Commissioner Gore.
Commissioner Gore.
No, that's all right.
Commissioner Gore.
Call the question.
Yeah, I mean,
how are we going to assign how are we going to select the individual?
That's what I was going to ask. I mean, we'd have to do that then at the next commission meeting?
Yeah.
I'm sorry?
How are we going to choose this attorney that is going to be the one that helps us and guides us?
I'll be glad to participate in that, and I think it should be someone independent without conflict, who can, not necessarily have an existing relationship with the city.
No, can have an existing relationship with the city.
Exactly.
Right.
So it'll be someone maybe from a little bit out of town. I don't know.
Mr. Chairman?
Yes.
I also want to follow up on the question that I originally had, parameters with regards to cost. I don't know if we're going to try to seek pro bono or what would be the cost, and then from what fund in the current budget will we get the money from? So, in other words, I want to see
cost cap.
A cost cap, number one, and then number two, from what fund, and I'll yield to the city manager for that.
I'm sorry, Commissioner. Did you say that? What did you say about me?
I said that I want parameters, a cap on the expenses,
And then from what fund will we receive those monies from?
Money would be coming out of the general fund.
Understood, but within the general funds, we have various accounts. As a matter of fact, we have a legal account for outside counsel.
Right.
Will we get it from there, except I don't know what currently is that amount for this current year?
Yeah, I don't know what's left in there. We've paid a lot of legal settlements, but even if it was already exhausted, that line item was already exhausted. If the will of this commission is to hire an outside attorney, then we'll hire an outside attorney, and we'll have to pay them whatever their fees are out of general fund. It will just impact our fund balance in the end of the year.
I'll tell you what's expensive is if we make a wrong decision based on having wrong information and we get sued by the developer, which we may end up anyway, it's going to cost a lot. And that's part of why we are where we are in this potential issue. So there will be a slight investment here for sure to get to the truth, or at least to the point where you all are comfortable with your decision. And even if this was unintentional from Victoria's side, is that good enough? That these documents were withheld and the story was withheld. It's not just the documents. I mean, other attorneys gave opposing opinions. Even the attorney that gave the final opinion agreeing with the attorney originally didn't agree with the attorney and opined with the Planning and Zoning Department. This to me, I spoke with Victoria this morning because I didn't want to completely blindside her from the dais with this and talked with her. And one of the things she said struck me. These are very fluid situations. When developers are approaching the Planning and Zoning Department, the attorneys get involved, everybody starts discussing, things can get misinterpreted. But one thing she said is, this is the way things have always been done. And that's part of my problem. We do have a process. We have a process for public appeal for the developer so that they can get the no they need and move on and do the warrant and not even be in this situation now. Or the yes at appeal. But for us to work it out like this is why we are where we are, and that's what's got to change. And I think this sends the statement that this needs to change, that our law department works for this city, it works for us as commissioners, and we direct them once they give us the advice. They don't work for the developers. They don't work for the land use attorneys. They are our representation. First and foremost, they need to give us the tools we need to make the right decisions and move forward properly. And I don't feel that was done here, and that's why I'm asking for this.
Mr. Chair?
Yes.
Whether we vote this up or down, realistically, it's going to come to the next commission meeting for us to actually choose someone. Is that correct? That's my understanding.
No, my intention was that the discussion item on the next agenda would actually be the future of the city commissioners.
Say that again, I'm sorry.
I mean, of the city attorney's office. My intention was that we would actually come to a decision at the next meeting.
Okay, and at that time we could come into some determination with regards to cost and caps and hourly rates.
I think you guys are not understanding each other. He was saying to put on the next commission meeting the decision itself.
Yep.
And I think what we're saying is...
It may take a lot longer.
Well, no, what we're saying is if you want to hire someone to represent independently to represent the commission, we need to choose that person, and that should be probably done at the next commission meeting because we all need to figure out who that person's going to be.
And then that person will need time to actually go through the information, because I'm sure this isn't the only case that they have if they're worth anything.
And Mr. Chair, at that time, we could discuss regarding to caps and what's it going to cost and so forth.
If we're going down that road. Is this the only, I just want to make sure I have all the information. Is this the only, I have two different sheets of paper, one from September 2nd, where Eleazar Melendez wrote Kevin Burns, who is our IT director. Kevin, in advance of an item to be considered next week, I need to research any communications between city staff and several lobbyists. Can you help us by running a citywide email search for 2015 and 2016 for the following addresses? Please let me know. Then he lists 1, 2, 3, 4, 5 email addresses, and then he comes back on the 7th and says, "Thank you for the information. It was a very helpful search. Can you help us again by running a citywide email archive search for 2015 and 16 for the following addresses?" And he adds in 3 more email addresses.
Yes.
So he doesn't. The
initial search revealed the specific names of the attorneys that had worked on the case. Mm-hmm. And so the secondary search was to expand on emails to and from those specific attorneys with the certain keywords.
So he never asked for the exact same information that he asked from the city attorney.
I believe this first email does do that, and then we asked for further information once we had specific email addresses in the result.
I have a question. I have a question / somewhat of a concern. Sorry. Have to look in your direction because you may be the only person I can ask the question to, which is, like, for example, as we've been having this discussion, we've realized that there were documents that you possessed that were relevant to this discussion. And so as we talked about it, you know, you had the search document of what you requested. Then, you know, we later found out that there was another document that was requested. So my question is, if we need to request documents in terms of our figuring out what happened here, who do we make the request to? Do we
Send a formal public records request to my office, but word it correctly.
Is that something that we can do, or do we do it through, because of Sunshine, is that something that we can do, or do we have to go through the clerk? Because now we have a different legal obligation, which is Sunshine. Because it won't be in a meeting. It'll be, because we're in a meeting now, so I can ask you anything. But outside of a meeting, even though I'm also a taxpayer, I'm also a citizen of the city of Miami, I'm also entitled to public records, I have an additional obligation, which is I can't talk to any of you outside of a public meeting about public business. So my question is, if we have records that we want to ask for, who do we ask them of?
IT?
You can certainly submit them to me, and then I can forward them along to the appropriate entity.
Fantastic.
So at the next commission meeting, our intention would be then to choose this independent person. That'll be the item I'll put on the agenda.
And so I'm clear, the independent person is supposed to review my opinion or review the fact that you feel that I withheld documents from you, or review, I think that needs to be placed.
All of the above, and whatever the commission would like to ask of that attorney.
That's the motion on the floor. Is there any further discussion or unreadiness about the motion on the floor?
Can you clarify the motion? Sorry, just to be perfectly clear.
Yes. I move that we put an item on the next agenda to select an independent attorney to report to this commission and work with this commission on the issue at hand with regard to Battersea Woods, Victoria Mendez, and the Planning and Zoning Department.
Motion has been clarified. Any further discussion?
And Commissioner Correa, I'm going to have you as the seconder still for this motion. Is that correct, sir?
Yes, but I stepped out for a second. Could you just repeat that? I'm sorry, Vice Chairman.
Todd, you can do it now, right?
No, probably best.
Okay, I'll do it again. I move that we put an item on the next City Commission agenda to select an independent attorney to study the documents and the situation with regard to Battersea Woods, their development attorney, their land use attorney, our law department, and the Planning and Zoning Department. Would you like to add a cap as an amendment?
I think we could actually do it at the next commission meeting when it comes before us.
All right. Any further discussion on that? It's really not. Any further discussion on that? Any unreadiness? So, all in favor of that motion, say aye.
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 All against? 2-1 nay. Motion passes.
And is that unanimous, sir?
No, I'm not.
Motion passes 4-1. Commissioner Hardman voting no. Understood.
Okay.